Hello and welcome to this panel hosted by the New Republic. It's titled Court Battles, a SCOTUS Update. As you all know, the Supreme Court just concluded its most recent 2024 through 2025 term, and it was a big one. Lots of big cases on the Trump administration's first return back to the court. Lots of implications for immigration, for executive power, for religious freedom and LGBTQ rights. I'm blessed that today we have an excellent panel of legal experts to help us navigate all of this. We have Jamal Greene, a professor at Columbia Law School, who worked in the Department of Justice's Office of Legal Counsel from 2023 to 2024. He's a constitutional law expert. We have Leah Litman, who is a University of Michigan law professor and the author of Lawless, How the Supreme Court Runs on Conservative Grievance, Fringe Theories, and Bad Vibes. She's also the co-host of the Scrutiny podcast. And we also have Steve Vladeck, who's a Georgetown University law professor, the author of One First, Substack that covers now, thanks to the Supreme Court's pace of opinions, almost daily, various updates in the law. And for that reason, Steve, I'll start with you. You sort of wrote the book on the court's use of the shadow docket. That practice seems to be in flux now that the court has rendered its decision in Trump v. Costa, which appears to have eliminated nationwide injunctions in most of these cases. Is the shadow docket now gone?
I think to the contrary, Matt, I think the shadow docket is going to become an even busier and more significant part of the court's work. And I think that Friday's ruling in the birthright citizenship case is going to help to underscore that. So just really quickly, I mean, there's a lot of weeds we can get into here, and I suspect we will. But the real top line here, I think, is less about Justice Barrett's majority opinion than it is about Justice Kavanaugh's really quite remarkable concurring opinion, where, Justice Kavanaugh says the real question in all of these cases, and by that he means, Matt, all of these, by my count now, 20 emergency applications the Trump administration has brought to the Supreme Court just in the last 5 months. The question is, while these cases are taking 2 to 3 years to get to the Supreme Court, what should the interim rule be? Should there be a uniform national interim rule? And if so, who should make that rule? And Matt, what's really striking about Justice Kavanaugh's opinion is, in one breath, he says, in most cases, there should be a uniform national interim rule, and we, the Supreme Court, should be the ones to make it, which seems to augur a much more active Supreme Court when it comes to emergency applications. But then, Matt, he says this in an opinion concurring in a decision in which the Supreme Court did not hand down a uniform national interim rule with regard to the birthright citizenship executive order. And so I think part of the problem here, Matt, is that the court is grasping for a theory to defend its really unprecedented number of interventions in emergency applications, and it doesn't have one yet. And the notion that we should always be providing a uniform national rule, I think one is not necessarily normatively obvious, and two is one the court hasn't followed at all. And so we have, on the one hand, a court that's been incredibly active in granting relief over and over and over again to the Trump administration. Now, on the other hand, a court that hasn't yet told us why, whether that's because they think the government's going to win on the merits in some, most, or all of these cases, or if this is just because the court, wants to let these policies go into effect and worry about whether they're legal at some point in the future, never mind all the harm and all the damage that they'll incur in the interim.
And one of the most important consequences of the decision was limiting the lower court's powers to sort of set any precursor to this. With the nationwide injunctions, they could sort of set a national policy, and then the appeals courts would review it, and then the Supreme Court would decide. But that seems to be in flux now. So I want to ask Jamal, how does this change how lower courts are going to handle high-profile, politically charged cases in the future?
Well, I think as Steve implies, these cases aren't going to go away, and there are still going to be lots of ways for lower courts to do things that the Supreme Court thinks are controversial, whether it's vacating an agency policy under the Administrative Procedure Act, which is still something that the court has at least nominally left available, whether it is certifying a nationwide class or granting nationwide class action relief prior to certification, which is what the court sort of suggested is the right approach in the birthright citizenship case, but we'll see how that in fact goes since that's already in train. Whether it's crafting a non-universal injunction or non-nationwide injunction that the government argues is broader than necessary, which we can expect to happen in future cases as well. So the form that that various requests for relief from litigants take is going to change after this decision, but fights over whether the government can be stopped from doing the things it's trying to do and exactly how much and where it can be stopped are not going to end. And as Steve suggests, the Supreme Court may very well be even more active than it was before in trying to resolve a lot of those issues.
And as we go forward, part of the calculus that the court used here for its own determination was the irreparable harm standard. And when most people think of birthright citizenship and a case that was at the heart of this, although the court didn't resolve birthright citizenship per se and the issues there, they did create a practical outcome where within, I think, the next 25 days, it's going to take effect in some jurisdictions. But the irreparable harm standard, you would think, would apply to the people who are in imminent threat of being rendered stateless. Instead, the court said that the imminent harm standard actually fell in favor of the government, that the government has the real burden here. Lee, how do we regard that as indicative of what the court might ultimately do on the merits? What does that say about the court's thinking in this case?
So I'm not sure that says anything about the court's disposition on the merits, but what I do think it suggests is the vast amount of discretion that the Supreme Court exercised in electing to hear this case and in what it resolved in this case. And how it exercised that discretion is, I think, some of the more concerning and appalling aspects of the decision. So as Steve has written about on 1/1, the Biden administration asked the Supreme Court to take up the issue of nationwide injunctions during the end of their tenure. The Supreme Court elected not to do so. Instead, they waited to do so until the first few months of the Trump administration, and they elected to do so in a case where the administration's lawlessness and legal violations are most transparent. And they did that in the context of an administration that is engaged, in my view, in basically an all-out attack on the legitimacy of lower federal courts enforcing federal law against the administration. They have called for judges to be impeached. Federal judges are experiencing a rise in threats. They have suggested that all of the rulings against them are illegitimate, unconstitutional, and unlawful. And by selecting this case in this context, the Supreme Court, I worry, gave some cover to what the administration is doing and emboldened them, because what they said is, of all the things that are problematic in this case, the one we are focused on is the behavior of the lower federal courts, not the administration that is engaged in the blatant violations of the law. So when you mention the irreparable harm standard, other aspects of the standard for discretionary relief are a likelihood of success on the merits. The Supreme Court could have opted to decide the lawfulness of the birthright citizenship executive order. It decided not to. And it exercised its discretion, again, to select this case in this moment. And I worry, again, what that is going to do for the Trump administration's posture vis-a-vis the lower federal courts and the court's miscalculus, I think grave miscalculus of the irreparable harm on various emergency applications is one of the worst aspects, I think, of its disposition on the shadow docket. So birthright citizenship kind of spanned shadow docket and regular docket, but this was an aspect of Justice Sotomayor's dissent in Department of Homeland Security versus DVD, which is about third country removals, where the government is trying to send people to third countries, countries that aren't their place of citizenship, country of origin, might not have been designated for removal in a removal order, without due process and without informing them that they have the opportunity to challenge where they're being deported. And the administration is trying to send people to Libya, where people who are in prison at risk of being trafficked or sold into slavery, and Sudan, a country on the brink of a civil war. And Justice Sotomayor said, look, by granting the government's application here, you, Supreme Court, are treating the real harm here as the government temporarily not being able to do something it wants to do, which is basically depriving people of due process while ignoring the grave risks of violence, death, and more that individuals who are potentially deported to these places could face. Did we lose Matt? I think, oh, maybe he's back.
Matt is muted.
I apologize there. I don't know what happened with that technical issue. You mentioned the removal cases, and one of the things that struck me about them is the justices' approach to how you bring these cases before the court. We know in one of them they said, well, no, you can't use Section 1983. You have to use habeas. Now that somebody has done something here, they say, no, you have to do that. There seems to be sort of a lot of shifting around. How do we see this within the court's broader approach to how people get access to the courts and seek remedies? Leah?
So I think another notable trend in the Supreme Court's cases this year is basically giving a leg up to favored litigants in making it easier for them to access not only the court system in general, but also the courts they would like to litigate in, while making it more difficult for disfavored groups to access the courts at all. So in the Planned Parenthood decision about whether patients and providers can challenge a state's decision to boot a provider from the Medicaid program in violation of federal law, the Supreme Court said you cannot bring suit to enforce that provision of the Medicaid. Because the general civil rights statute generally doesn't allow you to enforce spending power legislation. Around the same time, they issued a decision in Diamond Alternative Energy versus EPA, in which they said that fuel producers could challenge California and the EPA's, agreement about certain California regulations. Now, the Supreme Court didn't have to decide that question because the Trump administration told the court they were in the process of revisiting the regulation that is being challenged. And yet the Supreme Court plowed ahead, right, and decided a question that, in Justice Jackson's words in dissent, is going to make it easier to attack the Clean Air Act and give rise to the perception that the court makes it easier for moneyed corporate interests to access the court while sticking it to disfavored plaintiffs. She raised the same point in her dissent on the birthright citizenship case, indicating that the Supreme Court's limitations on the power of the lower federal courts were going to disproportionately burden those with fewer resources, the poor, and other groups, while at the same time, allowing corporate interests, their selection of where to file in federal court. So I think the Supreme Court has been narrowing remedies when it comes to disfavored litigants and disfavored rights. At the same time, it has greatly expanded access to the federal courts and litigants' selection about where to file when it comes to their preferred litigants.
Jamal, I noticed that you mentioned on Blue Sky, it was a post that really stood out to me during the opinion day last Friday, where you sort of expressed some confusion about why the court, maybe confusion is not the right word, but you asked why the court would choose this particular case, the birthright citizenship case, to make such a major ruling on nationwide injunctions when, as evidenced by the court's docket, they have no shortage of opportunities to consider the constitutionality, the legality of nationwide injunctions. What do you think about why the court chose this case to make this decision?
Well, I think, Matt, if I'm being generous with the court, which sometimes I am, I think that they probably thought that a case in which, well, they probably thought a couple of things. One is, I think the majority has persuaded itself that this was its first kind of square opportunity to decide whether nationwide injunctions were consistent with the Judiciary Act of 1789, where previous instances in which Biden administration has questioned nationwide injunctions maybe wasn't as squarely before them. I think they've persuaded themselves of that. But I think, in addition, I think there's a kind of I think it's a kind of twisted logic that says a case in which the merits are completely clear is the best case to decide this kind of issue because it really kind of closes the door, right? If you say in this case that a nationwide injunction is not available, a case in which the merits are quite clear, a case in which the government hasn't even challenged the merits before the Supreme Court, a case in which manifestly chaos will result if this executive order goes into effect, that if they say that nationwide injunctions aren't available here, it's a kind of clean presentation of the issue in a way in which it's not going to be kind of mixed up with the merits. I think that there are lots of problems with that. One problem being that, in fact, chaos will result if this goes into effect, and there's no guarantee at this point that it won't. Two, the court is charged, especially in cases in which it has a choice, with preserving its own legitimacy in the eyes of the public. That's always been a role that the court plays. And when you see a court that seems uninterested in the use of universal or nationwide injunctions when a Biden administration policy is at issue, and by the way, Justice Barrett mentions times when members of the majority have mentioned their discomfort with nationwide injunctions, but those are all in cases in which it was either a Trump administration policy or a red state policy, not Biden administration policies. And then now, when something clearly lawless is happening from the Trump administration, and then you get a 6-3 decision going in this direction, it really calls into question the legitimacy of the public legitimacy of the court. I'll also say that there are a lot of there are off ramps here. There are lots of things the court could have done. As Leah says, they could have just decided the merits if they're acting in good faith. It should have taken them no more time to decide the merits than it did to write this nationwide injunction opinion. And then you can preserve that issue for a different time. They could have just decided in this case that in order to provide complete relief to the state plaintiffs, that this had to be a universal injunction, that something that was decided below, that they chose to just pretend wasn't decided below, right? So there were lots of other avenues to go down here. And the fact that they didn't, again, it calls into question their impartiality. I'm not saying it necessarily reflects a partial court, but it certainly looks that way. And it's part of their job to make sure that it doesn't look that way. And there were lots of ways to avoid that.
Steve, you wrote also in a sort of a similar vein that when we had the big bang of cases last Friday, which, as a legal journalist was always my worst nightmare, that they would release every major case all at once. I used to have stress dreams about that when I was a kid. Now I have stress dreams about much different stuff. But you raised concerns that that sort of revealed that the court was being much more selective in who it favored for access to the courts. As Jamal mentioned about impartiality, what do we really know now about whether this court is able to accurately, if not act impartially, at least portray itself as such?
Yeah, I mean, it's a great question, Matt. I guess I wonder how much at least the conservative justices are actually worried about that. Because, I mean, Jamal's exactly right and Leah's exactly right. Like, the court had so many opportunities this term to look like it was speaking, if not in one voice, Matt, then at least in what we might think of as a more institutionalist voice. I mean, I think the court actually did that to some degree in the TikTok case, which, hard to believe, was in the middle of this term. Feels like it was about 8 years ago. And I think the court, based on which cases it decided to decide, based on which applications it decided to grant, based on even the fact that it held oral argument on the birthright citizenship applications. There are so many different moments where the court could have chosen institutional consensus and instead really appears to have leaned into, we've got the votes and you don't. And that's it's hard to sort of point to any one case as proof positive of that. But I just think the context of the birthright citizenship case is so important. There have been decent cross-spectrum concerns raised about universal injunctions for some time. There was such a better way to do it. And the fact that the court both did it this way and doesn't seem to care, and if anything, bristled at the suggestions in the dissents that the court was, legitimizing lawless behavior by the Trump administration, I think really suggests that the court, or at least a majority of it, does not view our current moment, or at least won't publicly admit that our current moment is as dire a challenge to the rule of law as I think for a lot of us it feels to be. And I think, Matt, if there's one thing about this term that I find the most disappointing, it's that. Right? It's that, maybe there are justices behind the scenes who understand exactly how much of a threat Trump is, but they won't say it and they won't act like it. And if John Roberts thinks that, his one public comment on was April 2nd, I guess, right, that we don't impeach judges we disagree with, we appeal their decisions. If he thinks that was it, and then turned around and issued, 14 different rulings on emergency applications that all favored President Trump, I just think he's living in a very different world than I am. And I worry that, the justices have become so cloistered in this respect that they're just not in a position where they even think it's a moment worth meeting, let alone meeting that moment.
Well, so he issued a second statement right after they finished releasing decisions in which he suggested that people who are criticizing the court too seriously and suggesting that the court is acting political are enabling the kind of threats against the lower courts, that the president and his allies are, by, again, posting images of judges while suggesting the judges are behaving illegitimately, corruptly, and alike. And then, sorry, Matt, your question, like, are the justices concerned? I feel like they genuinely don't care, and they don't care for two reasons. One is they inhabit this closed media ecosystem in which they are fed a steady diet of affirmation and validation when they reach the results that are preferred by the Republican Party base. And when Justice Barrett is attacked for departing from, the Trump administration and her Republican colleagues in a few shadow docket orders. And I think that again, like, splintered media ecosystem has replaced a world in which the justices were regularly getting input from a wider array of people. And then second is, I feel like rise of partisan polarization coupled with, like, the decline of our democratic institutions makes them much less concerned about where public opinion is, because they feel so much more insulated from the majority of the country, because they know, okay, popular vote, not sufficient to win the presidency, Senate, majority, not going to represent a majority of the American people. And where that's true, they know the likelihood of them being subject to more political control goes down significantly.
Well, that's perfect, because that leads into my next question. I'll ask you first, Leah, but then I'd love to get Jamal and Steve's thoughts on this as well. We saw during the first Trump administration, we had kind of the luxury, quote unquote, of a split screen here. They were able to rule against the Trump administration on multiple occasions. They did so on DACA, they did so on the census citizenship question. They also ruled for him on the travel ban. So we saw sort of a mixed bag there. So far, early sample size, but it seems to be shifting much more in one direction. Do we think that is, like I said, a sample size issue? Do we think that that's just an early example just from the types of litigation they've received so far? Or are we seeing a much broader shift here in how the court approaches this particular president?
So two things. One is, I think there probably is a shift, but I also think the rulings thus far against the Trump administration have been similar to the ones you described during the first administration. So on the shift, I do think that there is a shift, and that is attributable to the fact that this is now a 6-3 Republican appointed Supreme Court rather than a 5-4. The DACA rescission and the citizenship census case, those were instances where Chief Justice Roberts joined with the then 4 Democratic appointees. Now peeling off 1 Republican appointee is no longer sufficient. So I do think that affects, the likelihood that the Trump administration is going to succeed at the Supreme Court. And then second is I think bottom line of the 3 rulings that you identified, against the Trump administration during the first term were kind of a dot your I's, cross your T's, do a better job of lying and dressing up your animus or attempt to, do redistricting that will suppress, democratic political power in a way that strikes us as more plausible. And I think the Trump administration partially internalized that lesson. This is why the 4.0 version of the travel ban, it has not been subject to the same kind of challenges as 1, 2, and 3 versions of the travel ban, or in addition to the fact that the Supreme Court upheld the 3rd version. But I think that, this court has also become more comfortable signing off on some of the sloppiness of the Trump administration, as reflected in their own sloppiness in writing like the nationwide injunction opinion, for example.
Well, we could talk about I expect that we'll be dealing with the fallout of the CASA ruling for years to come, and I'm sure we could talk about it forever, but I do want to get briefly, well, not briefly, but more in depth on some of the other cases the court heard this term. One of the other big themes was religion, LGBT rights, the intersection thereof. Some cases dealt more with one than the other, but there seems to be sort of a medley there as the court considers how to balance the Constitution versus these competing arguments. And the first one that really stood out was Scrutiny, where the court held that transgender people and gender identity was not a suspect classification, that's the legal term, under the 14th Amendment's Equal Protection Clause. Jamal, I know you've written a lot about the 14th Amendment, which I guess you can say of any law professor. But I know that you've done some work on this. What did the court do that was new and different in that one, as opposed to their past rulings?
So I'm not sure the court would characterize themselves as doing something new and different, though I think they were doing something quite different than they've done in the past. So Scrutiny is this case involving a Tennessee law that banned medical procedures for minors that were designed for gender-affirming care. So that includes hormonal treatments and surgeries for minors. And the contention in the case was that this is a form of both discrimination on the basis of transgender status, but also discrimination on the basis of sex, because any number of procedures, including hormonal therapy, would be available for someone if it was gender affirming for a cisgendered person, but not available if you change the sex of the person. That would run afoul of the law. And so it's a fairly straightforward argument that that's a form of sex discrimination. And the lower court, in this case the Sixth Circuit, had said that it wasn't sex discrimination because it's a medical procedure, and medical procedures are typically often sex specific. And what the court here says, and what I think is a bit odd, and they had to do a little bit of dancing to get there, is that it's not sex discrimination at all. And so rational basis review applies. And the kind of argument that the majority uses here, and here it's Chief Justice Roberts, was the kind of argument that sort of is reminiscent of sort of segregation era cases, where the court says, well, because it's available, it doesn't punish or burden males any more than females, therefore it can't be sex discrimination. When in fact it's quite sensitive to what the sex of the patient is. And clearly the court got there, and I think this is part of what I find disturbing about the case, which and I'll note, by the way, that I don't find this an easy case on the merits ultimately, but I do think that what's disturbing about the case, among other things, is this idea that this enormous burden on people who are trying to seek medical attention in a gender affirming way is of no consequence when it comes to whether the law is constitutional or not, right? So when you decide that rational basis review is the way in which you're going to review a law like this, then it's equivalent of saying it doesn't matter how burdensome this was. We're just going to affirm it. Whereas the alternative would have been to say, this is sex discrimination, intermediate scrutiny, a higher form of scrutiny, therefore applies. And so the government really needs to do some work to show that this is a really important piece of legislation. And how that comes out, you argue about it, you let the lawyers decide, you let the lawyers argue about it, you make a decision. But the idea that it's just doesn't matter, that this is incredibly important to people's livelihoods, indeed to their lives, was I thought incredibly problematic and defied logic on its own terms.
Does that portend how the court will affect, I'm sorry, let me rephrase that. Does that portend how the court might change its approach in other areas of discrimination? This was very specifically about transgender rights and gender-affirming bans, but as we all know, the 14th Amendment stretches much more broadly than that. The Equal Protection Clause has a much greater scope than that. Will we see them try to take a narrower approach and defer more towards rational basis review in other circumstances that might otherwise seem like discrimination now?
Well, I think it's hard to say insofar as kind of the modern frontier of 14th Amendment equal protection law is in transgender rights, and whether it's in this case surgeries or medical interventions of other kinds, in other cases sports teams, in other cases bathroom access. So yeah, I do think the court signaled quite strongly that it's not inclined to be especially sensitive to the constitutional claims of transgender litigants in these cases. And so pretty clearly not going to define transgender status as a suspect classification. And Justice Barrett wrote a concurring opinion in Scrutiny where she, the court doesn't actually say that transgender status is not a suspect classification. In Scrutiny, they punt that question, but Justice Barrett writes a concurring opinion in which she says that she thinks the court should go there and articulates a fairly narrow test for how to define a suspect classification. So I think the court is sending pretty clear signals about transgender rights. I'd be hesitant to read more into it than that, given the very controversial politics around that particular classification.
Well, in 2022, I believe it was, we had the court's ruling in Bostock v. Clayton County, where the justices held that Title VII of the Civil Rights Act of 1964, that also protected the ban on discrimination on the basis of sex, and that ruling also protected sexual orientation and gender identity. I know a lot of people at the time saw that as a positive sign. They thought that that would mean that the court wasn't going to be hostile to LGBT rights, which, given the generally socially conservative direction it was going in, gave some people some hope. Leah, we've seen between that and the court's ruling in Mahmoud v. Taylor on the First Amendment challenge to the LGBT-related books in schools, we've seen sort of a shift in the other direction this term. Where should people see now the court heading?
Yeah, so I guess I would say three things. One is, Bostock versus Clayton County was a very important decision, but in the court's reasoning in that case, the court flagged that it was not resolving what could be a major carve out to the decision, which is whether individuals with religious objections to LGBT equality would be subject to the federal law that prohibited discrimination on the basis of sexual orientation and gender identity. So in some ways, Bostock resolved an important question, but it didn't decide the issue where the rubber has kind of hit the road on LGBT equality, which a lot of these cases have been framed in terms of individuals with religious objections to LGBT equality. And in fact, that style of case has been the ways in which, the court has recognized different exemptions from certain civil rights laws, in recent decisions like 303 Creative versus Lawless. Second is, I think the combination of Mahmoud versus Taylor and Scrutiny are quite striking if you kind of think about what the court views as, problematic burdens on different groups that warrant careful judicial scrutiny, and also how it is conceiving of LGBT equality and LGBT rights. So in Mahmoud versus Taylor, the Supreme Court said, because the nature of this instruction, which was LGBTQ inclusive storybooks in elementary schools, because the nature of that instruction was both normative and an objective threat to parents inculcating, their religious values in their children. They would subject the law to rigorous scrutiny, even though the law did not distinguish on the basis of religion. Whereas in Scrutiny, they kind of go through some gymnastics to say, even though the law doesn't discriminate on the basis of gender identity, we are going to treat it as just fine, even though the burdens of this law fall exclusively on transgender minors. And so I think the court's differential treatment of which kinds of burdens it cares about and which kinds it doesn't is another revealing indication of how the court seems to be catering and fashioning the law, based on whether certain litigants are favored and based on whether certain rights are favored as well. The third thing I would say is, I think the reasoning in Scrutiny is probably the best version of that case we could have hoped for given its outcome. And yet, I worry that the depiction of the transgender community in that case is not so much as a community, but instead as an ideology. And I think you see that same framing in Mahmoud, where again, like the mere exposure to the existence of LGBT people is treated as some sort of indoctrination, as if it is, nothing more than woke ideology. And so I think that kind of reasoning also reflects a very harsh, unsympathetic orientation to LGBT rights that, appears in more than a few of the court's cases. And I think warrants considerable concern about where the court is going to go on LGBT civil rights in the future.
I want to ask also viewers, if you have any questions, we do have the Q&A webinar chat where you are feel free to contribute to them. I know some of our contributors are answering some of them. And Steve, you were talking about, speaking of, by the way the court prioritizes certain groups and deprioritizes others. We mentioned earlier about DVD. That was one of the removal cases. It dealt with third country removals. Steve, can you clarify a bit why that case was so important, especially in terms of how the Trump administration behaved in the lower courts?
Sure. I mean, I think there are two different reasons why the DVD case is, I think, both really important and really alarming. So first, on the substance, the actual question in that case is about migrants who have been held removable through ordinary immigration proceedings, but then the government comes along and says, we actually want to remove you to a different country than the one that we identified in your removal proceeding. And the question, Matt, is whether at that point, those individuals have a right to basically object to being sent to that specific country because they fear that they'll be tortured or otherwise mistreated in that country. These are known as third country removals. And, federal law, at least since the United States signed the UN Convention Against Torture, has reflected the right to object in those circumstances, which is part of why a district judge in Massachusetts required the federal government to provide notice and an opportunity to contest one of those removals before they're effectuated. So it didn't actually block the removals, just said, hey, government, you got to dot the I's and cross the T's before you do it. The government defied that district judge not once, but twice, including, I think, most notoriously in the news when it sent 8 men. At least initially the plan was to send them to South Sudan. They ended up in Djibouti. And notwithstanding the government's behavior, the government went to the Supreme Court and said, you've got to, freeze the district court's injunction. You have to let us continue these third country removals. And the Supreme Court said, sure. And in an unsigned, unexplained ruling last Monday, the court cleared the way for the government to resume those removals. And Matt, that strikes me as problematic for 2 different reasons. The first is, this is the same court that as recently as April 7th in the Alien Enemies Act decision, JGG, had said, well, obviously, before folks are removed under the Alien Enemies Act, they have a right to notice and an opportunity to be heard. Seemingly that's not applying to the folks in the third country removal category. But second, even if the government has a good case on the merits for why this case is different, for why maybe there are, technical jurisdictional statutes that precluded the district court from doing what it did, the fact that the court blessed the government's behavior in a context in which it had openly defied the district judge, I think is sending a really dangerous message about how much or how little the Supreme Court is going to get the backs of district court judges. And, Matt, that's in contrast to the Supreme Court protecting its own rear. We all saw that after midnight ruling back in April, where the court blocked the seemingly imminent removal of a group of migrants under the Alien Enemies Act from the Northern District of Texas. I had hoped at the time that that was the court finally turning a corner and really standing up for due process. The more the time goes on, and Matt, especially in light of the DVD case, the more it looks like the court wasn't protecting due process, it was protecting its own mandate. And that, defying the Supreme Court, oh, we're going to come after you, but defying district courts, no problem. That strikes me, Matt, as both a under-theorized view of which courts do and do not have power, and a very dangerous one, because the more, this was Justice Sotomayor's point in her dissent in DVD, the more that the court is rewarding this behavior, the more it is adding credence to the attacks on district courts, whether they're substantive attacks or threats or impeachment, resolutions. And it seems like that's something the court really should not be in the business of doing at this point.
I want to get back also to some of the environmental cases this term. We had a series of major rulings on California's vehicle emissions standards. We had some Clean Air Act rulings earlier as well. They really seem to suggest that the court is particularly interested in this. We've also seen past terms they've gone out of their way to address these questions as well. How is the court's approach to that? Because, well, I'm sorry, let me rephrase that. In the dissent in, I believe it was the California case, Justice Jackson called out the court for its adherence to moneyed interest, that it was deferring to them too much, that it was damaging the public perception of the court. Jamal, what does it mean for a justice to make a warning like that, and how seriously should the court take it, especially in these environmental law cases?
Well, of course, Justice Jackson is writing in dissent, and I think that look, I think it's, and this is a theme across this this court, and not just this year, but many other terms as well, which is this is a really conservative court, and that doesn't just mean there's some kind of arcane other universe of a spectrum of conservative to liberal. That just exists within the law and is not connected to politics in some way. When we encounter a conservative in the world and encounter a conservative on the Supreme Court, those are basically the same person. I'm not suggesting in saying this that there's something, that they're sort of not doing their job or something along those lines. People take their politics with them to these cases, and some of those politics, I think, intersect in various ways with views about the law. And in the environmental space, those views about the law are views about exactly how much the EPA is able to do when it's enforcing the Clean Air Act or when it's enforcing the Clean Water Act. And so we see in a number of these cases, the court, for example, limiting the ways in which the EPA can limit a permitting for releasing effluents into the Pacific Ocean, imposing greater requirements of deference on district courts to environmental impact statements, just reflect a view about environmental regulation that again reflects the politics of the court. If you look at some of the measures that political scientists use about the court and how conservative it is, the more or less median justice on the court is approximately where the median voter in the Republican Party is, right? Which is to say that instead of being in the middle of the country, it's in the middle of one of the center right or right party in the country. And so I'm not sure there's more to it than that, which is just, there's going to be disagreements about agency power in these cases. There's going to be disagreements about statutory interpretation in these cases. And you see it on the left and the right, that it sort of points in broadly political directions, and that's something we have come to expect and should continue to expect.
One of the areas where we've seen the most energy on the shadow docket, especially since Inauguration Day, has been with the civil service in general. There have been a lot of cases, some of which have flown under the radar, some of which become more prominent, about removal powers, and specifically not just for principal officers of federal agencies, but also for just rank and file civil servants. One of the ones that stuck out to me most was earlier this year when the court said that, Humphrey's executor, when it essentially overturned it, but then said that the Federal Reserve didn't fall into that. Leah, you've written about how, and I believe your book's title makes this very explicit, that the court is going just based off vibes. Is there a better example of that than that ruling? What is the what is the big takeaway from the court's decision to carve out that exception there?
Okay, so in order to try to convey just how lawless this decision was, I think it's important to recognize that this case did not involve the Federal Reserve Board. It involved the heads of two other multi-member commissions, the National Labor Relations Board, as well as the Merit Systems Protection Board. And yet, in the course of announcing that the president had the authority to fire the heads of those other multi-member commissions, relying on reasoning that seemed to suggest the president would have the authority to fire the heads of most/all multi-member commissions that have, some significant power, the Supreme Court added a paragraph that said, "Oh, but not the Federal Reserve Board," of course, because giving the president the authority to fire the heads of the Federal Reserve Board would threaten the collapse of the United States economy. And so what the Supreme Court did is it just announced this ad hoc exception to the new rule it just fashioned. Justice Kagan in her dissent called it a bespoke exception for the Fed. The court strung together some words and phrases that do not, in my view, plausibly resemble law or legal analysis. What they said is the Federal Reserve is a uniquely structured quasi-private entity that follows in the distinct historical tradition of the first and second banks. Again, those are words. Maybe they're a descriptive statement about the history of the Fed. I think that's even debatable, but they surely don't explain why the president wouldn't have the authority to fire the heads of the Federal Reserve Board. So I think that this just represents, an ad hoc exception the Supreme Court made up because to them, seems like Congress has pretty good reasons for insulating the heads of the Federal Reserve Board from presidential removal, whereas it doesn't think the same of Congress's reasons for insulating the heads of all other multi-member commissions from presidential removal. And that kind of just base judicial second guessing, this freewheeling, assessment of what's good and what's bad policy, underlies, I think, how they are fashioning the law, including in this case. I think the other remarkable part of this decision is the Supreme Court effectively overruled, a centuries-old precedent on the shadow docket without even mentioning it, of course, because Humphrey's executor had upheld removal restrictions on the heads of multi-member commissions. They're the Federal Trade Commission, and relying on that precedent, Congress has created restrictions on the removal of other heads of multi-member commissions. And what the Supreme Court did is they effectively allowed the president to, by fiat, determine he wanted to overrule Humphrey's executor and bet that the Supreme Court would let him do it. And they did. In her dissent, Justice Kagan said, what the Supreme Court has done in that order by allowing the president to fire the heads of the multi-member commissions in violation of federal law was to show more respect and concern for this president than our precedents. And I think that kind of characterization, again, about whose interests the court cares about and what they are trying to do is pretty pointed coming from, one of their colleagues. And, again, this decision is just, I think, one of the more transparently ridiculous ones we received this last year among many great candidates.
Can I just add now one quick point on that? I mean, I agree with everything Leah said. I'll just add, it's also worth pointing out a point that Justice Kagan also made in her dissent, which is it's especially striking for the Supreme Court to have done what it did in the Wilcox case in a context in which everybody agrees that under the governing Supreme Court precedents, the relevant statutes are constitutional, meaning the district court and the DC Circuit would have been flouting Supreme Court precedent to allow President Trump to remove those individuals. And so, I mean, yes, the Supreme Court isn't bound by its precedents the same way that lower courts are, right? But it just seems to be getting to this broader problem of, the Supreme Court sort of thinking that it can be whatever it wants and it can chastise lower courts in contexts in which the lower courts had no ability to do the thing the Supreme Court wants to do itself. I mean, it's a categorical error in what the justices think their role is and how they envision their role vis-a-vis lower court judges.
And just to add on, and I agree with what both Leah and Steve said on this case as well, is it to go back to the point about sort of what's the urgency here, which is, there's staying a lower court opinion here that relies on the law as it has been for the last 90 years, right? So the idea that, no, it's so urgent, we can't let the president wait another few months when the law has been as it has been, right, suggests a special solicitude, as Justice Kagan said, for this president, which is, to say the least, disturbing in light of the specific actions taken by this president, actions that suggest a desire to act as an authoritarian, to flout the legal constraints that Congress has put on the president's power in this domain. And the National Labor Relations Board was established in the same year that Humphrey's executive was decided. It requires some justification at a minimum. And then to go back to Steve's point, to do this, Steve and Leah's point, to do this as a shadow docket decision is really hard to justify.
Well, we're coming up on the end of our time here, and I wanted to just thank each of the panelists for agreeing to join us today. I really appreciate the illumination they were able to bring on some of these issues, especially the more complex ones. Some of these cases are straightforward, some of them are not. So I really appreciate that. I want to close with an eye towards the future. The court has already sort of announced some of its docket for next term, cases on gerrymandering, cases on conversion therapy bans. There are other ones as well. It's looking like another scorcher, so to speak. So I'd love to hear from each of the panelists, starting with Jamal. What you think is the most important case that's either currently before the court or that will percolate soon percolate in the lower courts and reach its docket soon?
Well, so on the latter question, the birthright citizenship case will come back on the merits. It may come back as soon as a couple of weeks from now, depending on what happens in the lower courts with class certification and so forth. But at a minimum, it's reasonably likely to come before the court in the next few months, and that'll be quite important. The other I'll mention is just, you mentioned gerrymandering, and there's a case out of Louisiana that really sits at the intersection of what is required under the Voting Rights Act and what's permissible in terms of structuring districts, congressional districts, and what's permitted under the Constitution when it comes to taking race into consideration and drawing district lines. This can get incredibly complicated. Voting Rights Act doctrine in this area is very complicated, and the court has been somewhat all over the place on this issue. But given that the court was going to hear this case this term and scheduled to be argued again next term with additional questions to be asked, that suggests to me that they're going to try to swing for the fences in terms of resetting the law in this area. And of course, how district lines are drawn affects all the rest of our politics. And so I think that's really one to keep a very close eye on.
So I agree with the, gerrymandering Voting Rights Act case, and also about the case on the ban on conversion therapy. In addition to the merits of birthright citizenship, getting back to the Supreme Court, I think the other set of questions that are likely to get back to the Supreme Court are about the scope of the exceptions to the Supreme Court's restrictions on nationwide injunctions, specifically when is class certification proper and when is that going to provide an effective substitute for nationwide relief? Second is when is it necessary to give states, effectively nationwide relief or relief to parties not before the court in order to remedy the harms to them. I think it's likely that those issues will also be up at the Supreme Court shadow docket in the next year. And I think that the scope of those exceptions and what the Supreme Court says about them are going to be quite important as far as what lower courts are able to do in the next few years.
Yeah, I mean, I'll just say, I mean, I think it is always a difficult task to try to figure out what the biggest case coming down the pipeline is, because you never know it when you see it. I don't know that folks would have expected the DVD case to be as important as it already has been. And in fact, it's already important again, because we're waiting for the Supreme Court to rule on a very strange request from the government for clarification of what its unexplained order actually meant. So, Matt, I don't know that it's any one case. I think the real question is, when these Trump-related cases get to the justices on the merits, are we actually going to see backbone from the court? Or are they going to acquiesce and appease the administration in the same ways they've done so far? I mean, we've had, by my count, 17 rulings to date on Trump-related emergency applications. And in 16 of them, the court has said nothing at all about the substantive validity of President Trump's actions. Only Wilcox, which we talked about, right, where the court came pretty darn close to blessing the firings of Kathy Harris and Gwen Wilcox. Did the court say anything substantive? So, Matt, I'm looking for those cases, when, not if, birthright citizenship comes back, when, not if, the Alien Enemies Act comes back. Is the court actually going to legalize President Trump's, to my view, patently lawless behavior? Or when it finally can't, duck, when it finally can't use the procedural contrivances of emergency relief to sidestep confrontations, will there be 5 votes in any or a meaningful subset of these cases to say actually the president's acting unlawfully? Or has the court either bought into or at least been scared off of, right, the institutional role that the Trump administration envisions for everybody else, which is just furthering the Trump administration's agenda? That, to me, is the question. And it's hard to know in advance when it will appear first, but it's clearly coming sooner rather than later.
Well, I want to thank all 3 of our panelists, Steve, Leah, Jamal, for joining us today. This was a really excellent discussion. These are 3 legal experts whom I've admired for many years, and it's always a joy to get to talk to them, if not firsthand, then at least through the magic of modern telecommunications. You can read all of their work on their various projects, which we have listed on the event page on our website. You can also follow myself and the 3 of them on Blue Sky. Thank you, everyone, for joining us for this TNR event. You can see our events page at tnr.com to see when our next event will be. Thank you so much, and I look forward to seeing you guys at the next one.
Thanks, everybody.